Okay, it says I'm live. I could be live. Am I live? Cat, am I live? My phone says I'm live. See, anybody here? 4 people here? Let's see. I just got this guy right here, which is the state's response to the Martinez-Arnold motion to reopen the civil forfeiture case. Okay, can anybody hear me? Sorry, my thing's being all messy today. Sorry about that. Hey, buddy. And my template's got all messed up since the last time I streamed. Sorry about that. I know what I did wrong. Give me 1 second. Oh, I'm sorry. I know this is thrilling TV. Okay, now get somewhere. Okay, that should be a little bit better. There we go. Yeah, so we're going to do a Demise McMullen stream today, but I wanted to start with this. I haven't read it yet. This is the state's response to Martinez-Arnold's motion to reopen the default in the civil asset forfeiture case in YSL. Hey, Kat. And I was trying to get the chat thing working for this stream, but I don't think it is working. Let me see. Yeah, that's okay. Let's get it next time. I'll just keep chat open on here on the side. And yeah, so I'm just going to start going through this. I haven't read it yet, so I hope it's good. Not really, but we will see. Okay, so response to Martinez-Arnold's motion to open default. Let's see, make sure the other stuff's right. Yeah, that looks right. Vying through its counsel, Bonnie Willis, District Attorney for the Atlanta Circuit, the undersigned, hereby files its response to Martinez-Arnold's motion to open default, moves to an order denying said motion, and in support thereof. I hate that to start. Georgia needs to stop doing this. It's too much. Just start here. It's fine. Okay, anyway. On May 9th, 2022, law enforcement officers executed a search warrant at Jeffrey Williams' house. Let's see. There, officers seized personal property, including currency, jewelry, numerous firearms, and various controlled substances from different areas. Officers also seized property from Martinez-Arnold, who was on the property during the search and was arrested there. Thereafter, the plaintiff state of Georgia, through the Fulton County DA's office, timely filed a complaint for forfeiture on July 7th and named, among others, Martinez-Arnold as an alleged owner, interest holder. Class just went live. Interest holder of some of the seized property. Briefly, this complaint for forfeiture alleged that the seized property was subject to forfeiture under Georgia law as tools and proceeds of racketeering activity. I don't remember them using that phrase, as tools and proceeds of gang activity and as items in close proximity to controlled substances. Arnold was timely served with a copy of the complaint on July 19th. The sheriff's entry of service was filed with the clerk of the court on August 1st. So the effective date of service was August 1st. That's true. As the Court of Appeals was affirmed, getting the procedural stuff. Answer is not timely filed, automatically becomes default. If the case remains in default for 15 days, the plaintiff at any time thereafter shall be entitled to verdict and judgment by default. Arnold was thus in default as a matter of law on 45 days after August 1st, or September 15th, 2022. The state of Georgia filed a motion for default as to Arnold on January 23rd, 2023. I'm excited to see if they deal with the stay in here at all, because they haven't mentioned it yet, which is kind of the whole point. We'll see. Arnold has now filed a motion to open on April 14th, or 943 days after he was in default, and after the plaintiff's date has been entitled to verdict and judgment by default. It seems like they're just going to completely skip the entire substance so far. I feel like I'm just going to be getting myself, but it doesn't seem like it. Kat asked, are they even dealing with the stay? It doesn't seem like it. That's the whole issue. Like, nobody disputes that you're allowed to get a default if the person doesn't answer. That's not really... We all agree on that part. Anyway, as the court has recently affirmed, the answer is not, they already said this, the answer is not timely filed. It remains in default for 15 days. The plaintiff shall be entitled to verdict and judgment. Arnold himself admits in his motion to open that he is in default, but a party may move to open default pursuant to 91155B. All five. That's right, AJ. This is just quoting the statute that says that defendants generally have an open to reopen, have the right, or at least should be permitted to reopen in default, because this is true across law. Generally, courts are resistant to impose a default judgment rather than deciding something on the merits and with the evidence. But anyway, the four conditions that the showing shall be made under. These are the conditions that need to be met to reopen the default. So the four conditions that the showing shall be made under oath, shall set up a meritorious defense, shall offer to plead immediately, and shall announce ready to proceed with the trial are conditions precedent for a court to then consider the three grounds of providential cause, excusable neglect, or a proper case having been made. I'm pretty sure they're misquoting that. Failure to show all four of the conditions precedent is fatal to a motion to open default. Plaintiff state concedes that Arnold has made a showing under oath, offered to plead, and has announced ready to proceed to trial, but the state contends that Arnold has not made a... Sorry, this is going to be funny. This is going to be good. That Arnold has not made a sufficient showing of a meritorious defense. There were like attachments and everything. Okay. If this court does determine that Arnold has met the four conditions, Plaintiff state also contends that Arnold has shown neither providential cause preventing the filing of pleadings, you locked him up, excusable neglect, again you locked him up, nor facts that would allow this court to find a proper case has been made. Open default. This is going to be fun. Georgia law is clear. Okay, the heading. Arnold has provided only mere conclusions and has not provided facts sufficient for a meritorious defense. Right back at you. Georgia law is clear that a showing made under oath setting up a defense is one that includes more than mere conclusions and must set forth facts that establish the essential elements of a defense. A meritorious defense has been found where the defendant sets out affidavits and documents containing facts. He did! Set out affidavits and documents containing facts that essentially disprove the allegations in the complaint. But while the affidavits or documents need not provide great detail. Yeah. This is a further episode. They must provide some detail beyond general denials. I guess they do need to provide great detail then. Anyway, Arnold has not provided any factual details of any significance to challenge the claims in the complaint and has instead provided mere general denials of the complaint. That's not true. He attached, hey, there's my favorite lawyer. She already responded? Those poor souls over at the DA's office. I just noticed I'm still on the Wi-Fi. I'm gonna grab, let me run out for 1 second. I'm gonna grab the Ethernet cable so I can make this wired. Then let me just move this up. Give me 1 second, I'll be right back. Okay. Sorry about that. Kat, I'm not surprised that she did. I mean, this is borderline frivolous, and it's not that borderline. Let me see. Here we go. In his affidavit attached to Exhibit A, Arnold makes various claims to why he did not timely file an answer. Nowhere does he even make any defense as to why the seized property was not forfeitable, as tools or proceeds of gang activity, tools or proceeds of racketeering activity, or property in close proximity to controlled substances. He did, though. He definitely did. He said a whole thing about how Gunna gave him the chain and the watch and the bracelet, and he bought the car and a million other things. I don't want to read this anymore. Okay, nor does Arnold in the verified answer attached as Exhibit C provide any level of factual information that rises to the level of a meritorious defense. This feels like they just took a template. Instead, Arnold offers mere general denials of the allegations in the complaint for forfeiture. At best, Arnold's verified answer sets out a defense that he is an owner of certain of the items of seized property. But alleged ownership is not at issue, as the plaintiff state has never contended that Arnold is not an owner of certain items and is not moving forfeiture of the items under a theory that Arnold was in possession of stolen property. Good, because that would be dumb. The rest of it's dumb, but that would also be dumb. Instead, the plaintiff state has alleged in its complaint for forfeiture that items are forfeitable because of their connection to certain crimes committed by Arnold. Did they, though? This is a separate issue from the issue of ownership, and Arnold has not provided any factual information. This is exhausting. They've written this sentence 6 times. Okay, we're moving on. Arnold's reasons here as to why he did not file an answer in his general denial of the complaint without any more are not defenses rising to a level of a meritorious defense. Georgia law, the court should dismiss his motion to open default. We deny, but okay. This doesn't have a year. This citation's wrong. Yeah, I don't know. Bamara asked, did they read the same motion we read from Ashley, or can they not comprehend? I don't know. But yeah, this is... I want to look this up real quick. Stewart... Wait, why would Stewart versus Turner? That'd be a civil case. That wouldn't even be an asset forfeiture case. It's not like Stewart versus Georgia, for example. 229, Georgia App 119. Yeah, this looks like it's just a... Hold on, see if I can get this for you. Yeah, it looks like it's this case here. And you can see it's just a general default case dating from 1997, it looks like. And it looks like a completely dissimilar case. Involves something involving a minor and the minor's guardian and possession and permission from the minor's guardian. I don't know how that relates, but anyway, moving on. AJ, yeah, I know. That's fair. I'll go back to this real quick. Arnold has not pleaded providential cause. I regret reading this on stream already. Arnold has not pleaded that there is providential cause preventing the filing of required pleadings, but to the extent this court considers this ground, there is not providential cause. Providential cause generally encompasses events over which a party or his attorney had no control, including illness, death, absence of counsel, acts of God. Lack of due diligence, which is exactly what we have here, is not providential cause. We do have lack of due diligence here. They're not wrong about that. It's not what they think. Lack of due diligence is not providential cause. Arnold has not alleged any of this, so he's not alleged a lack of due diligence, I guess. Again, doesn't really make sense. Go down to C. Arnold's not given any legitimate reason for his inaction. Well, he was in jail, so Arnold has not set out any reasons for his inaction, delay, and lack of diligence in filing an answer to the complaint. They still haven't gotten, Kat, you're right, they still haven't gotten to, the stay. That he'd be in contempt of court if he did. Anyway, I'm not set out any reason for his inaction, delay, and lack of diligence in filing an answer that rise to a level of excusable neglect. Instead, he blames everyone but himself. He knew his property had been seized for forfeiture. Hey, Ashley. Yet he did nothing for over 2.5 years to challenge the seizure. Some instances in which excusable neglect has been found in a contract dispute, they have nothing. When the defaulting party believed the dispute was settled after sending a check for final payment under the contract. Likewise, there is excusable neglect when there is reason to believe that the lawsuit is being defended by an insurance company. Okay, that's an example that makes sense. If you think an insurance company is defending you and so you don't answer and then they don't answer, that makes sense. That's excusable neglect. It doesn't have anything to do with this, but, On the other hand, it is not excusable neglect when the defaulting party notifies their attorney of receipt of the complaint but does not conduct diligence. to ensure that the attorney is handling the case. Does not conduct diligence. That's not a thing. Complaint to insurance. Yeah. Okay. Arnold claims that there has been excusable neglect that justifies opening the default, but he has not provided any reasonable excuses for why he did not file a timely answer in jail and stay, or a motion to open default. Arnold is correct that he was incarcerated at the time of being served and claims that he did not have the basic materials with which to respond. Oh, man. Hey, Mark in Texas. Nicole, I think it was it a body? No, it was the civil. These are the civil attorneys. It's Grant and I think Ashley something. Not that Ashley. Different Ashley. Did not have the basic materials which response. It's not clear what this means, but if it means that you do not have a pen or pencil, paper, and access to the mail in order to file an answer, then his contention is without a basis in fact. The court is surely aware of the multitude of pro se filings by people incarcerated in the Fulton County Jail. Oh man, this is going to be so fun in about an hour when I get to this. An envelope to be able to respond. Nowhere else in his affidavit does Arnold set out any fact or other claim as to why he did not timely file an answer within the 45-day time period. To give any reason why it took him more than 2.5 years to file anything after he had been released from jail. The audacity. He claims that he was told a stay was in effect, but as a defaulting party, he was not afforded the protection of a stay. Well, this is 40 years ago. We're gonna have to pull this one up. Okay, let's see here. This is the case that they decided to. Let's just read the synopsis and see if it sounds similar. The administratrix filed wrongful death action against other driver involved in automobile collision. So there was a car crash and somebody died, and their estate is suing the other driver. The Superior Court, Fulton County, entered default judgment against driver, denied motion to open default, and entered judgment on jury verdict against driver in favor of administratrix. So in this case, the court had already denied the motion to open default. So it's a different posture than it was in our case. Driver appealed, how that refusal to open default on basis of inadvertence was not an abuse of discretion. So the court's just saying that the court has the discretion to open. Yeah, that's what sounds like cat. There was a jury verdict, and they just said that the court had the discretion to refuse to open the default. Refusal to stay, wrongful death action. So refusal to stay, here the court didn't refuse to stay. The refusal to stay, wrongful death action until driver's insurer's interpleader action could be heard was not abuse of discretion. So again, it's just an abuse of discretion standard. Although proper party to have brought wrongful death action was decedent's illegitimate minor child by next friend. I don't remember what that means. And not administratrix, defect of failure of proper party to bring action. This does not sound relevant. Defendant was not prejudiced by occlusion. Yeah, this doesn't really sound particularly on point. It sounds more like the court just exercised its discretion to. Yeah, Kat. Ashley says they don't have his belongings anymore if I was a betting woman. It's definitely possible. There was a short window where I guess they would legally have been allowed to sell it, but they still would have had to they'd still have to pay him back for all the stuff at this point. So yeah, this quotation says, finally, appellant being in default had no right to a stay, as he was entitled to dispute only the amount of damages. What page is that? It's page 591. Let's go back to that real quick. Let's see what 591 says. Here it is, 591. Here it is. That's what they're quoting. We've reviewed the record and find the trial court did not abuse its discretion in refusing to let the stay remain in effect. Okay. So that the court lifted the stay. Further, the wrongful death action was entitled to priority over the interpleader action, as it was the first commenced and service was perfected. I wouldn't worry about that. Finally, appellant being in default had no right to a stay. Okay, so this is the quoted sentence. Finally, appellant being in default had no right to a stay, as he was entitled to dispute only the amount of damages. But that's discussing a stay that had been lifted, not whether there was a stay. Trenton asked, does ruling even give lip service to detrimental alliance? This one, I haven't read it through. I've never read it. Neither has the DA's office, I'm sure. But no, I don't think it does. I don't think it needs to either. I just don't think it's not relevant. Or I just think it's not relevant. But yeah, this is just in a positive completely. Arnold in paragraph 9 states that he had an attorney, although it is unclear when he hired this lawyer. Playing this game again. Assuming he hired a lawyer soon after service of the complaint. Oh, Ashley's going to be so mad about this. I can tell already. Assuming Ashley was in contact with them on August 31st, asking about this issue, and they sandbagged her. So they absolutely know that he had a lawyer. Assuming he had a lawyer soon after service, then his inaction and lack diligence in following up with his lawyer to see about the next steps, including the timely filing of a motion within 45 days of service. Filing of an answer is what they mean. Within 45 days of service is neglect wholly attributable to himself and does not rise to a level of excusable neglect sufficient to open default. If he has waited... Yeah, Trent, I agree. If he's waited until recently to hire an attorney, then this is likewise not excusable neglect. Oh, God. Okay. For not timely filing some sort of pleading pro se or for hiring an attorney to represent him, either way, Arnold's flagrant disregarding process of the court. Either way, Arnold's flagrant disregarding process of the court should not be found as grounds for opening default. This is just making me sad. It's so bad. Arnold has not set forth any claims or facts sufficient to allow this court to determine that injustice against Arnold would result in default is not opened under the proper case standard. The court must indeed look at all the facts and determine whether there is a proper case, and determining whether the defaulting party's failure to file a timely answer must not have This court must indeed look at all the facts in determining whether there is a proper case, and determining whether the defaulting party's failure to file a timely answer must not have resulted from willful or gross negligence. Yeah, Ashley, I don't know. And I mean, he's already explained. Ashley asks, how are the items related to a criminal organization when there was a no-low plea and a not guilty to close the trial? I don't know. And even if there were guilty pleas, you still need to show that these specific items are tied to the crime. And he's shown that they were, several of them at least were gifts. Arnold seeks to cloak himself with the protection. Excuse. This is just repeating the previous section. Arnold seeks to cloak himself with the protection of a stay of the case, but he cannot be afforded this protection as he was already in default. He's opening the default. This court should take all the facts into account. But when the defaulting party does not actually provide any facts to counter the claims in the complaint, then the court should not open default. In a just world, this would get you sanctioned. This is absurd. There were facts. should not be lost. The complaint incorporates the indictment in Fulton County Superior Court case number 182273, which was null prost, which alleged in count 1 that Martinez Arnold participated in a conspiracy. Oh, goodness. Arnold was later reindicted under 183572 to add 1 count of participation in criminal street gang activity. Yeah, you accused him of that. This is so bad. The criminal activity listing, both indictments, is the exact same criminal activity alleged in the complaint for forfeiture. Plead guilty to these counts. I need to check that real quick. I don't know if I believe them. Let's see. Arnold plea. So he actually got, what is this? 1, 2, 3, 4, 5 of the counts dismissed. And then there are guilty pleas to the RICO and to the gang activity. But these were the things that happened on May 9th. So he actually did not get convicted for the events of May 9th. Let's see what those counts are exactly. There's one which the RICO, I think it was 57. Yeah, there's this one. So this says that he must have pleaded guilty to participating in criminal street gang activity, commission of at least one of these offenses. But we don't know which one. So he didn't actually plead guilty to any of these specifically. That's kind of funny. Then I believe in the RICO, he only pleaded guilty to one of the overt acts from 2015. So that doesn't really work. Anyway, pleaded guilty to these counts, so he cannot now deny the allegations of these charges. Okay, doesn't matter though. Arnold makes conclusory statements that the property is not connected to the... Okay, this is insane. Arnold makes conclusory statements the property is not connected to the crimes, but offers not an iota of proof. I mean, there's like a whole attachment, but Arnold claims the forfeiture will result in a windfall for the state, but he is mistaken. The Georgia legislature has explicitly stated the forfeiture has a remedial purpose. And what better way to remediate racketeering activity and gang activity than to remove the tools and proceeds of these crimes from someone who has been convicted of these crimes? I think they thought that was good. It wasn't. 2022, certain of his property was seized. He was shortly thereafter served with a 113-page complaint explaining in detail what items were seized, when the items were seized, from where they were seized, and on what grounds they were seized. I don't even want to stream anymore. This is just sad. Now he's been given a chance to open default, but he only offers conclusive assertions without any elaboration as to any sort of meritorious defense. Nor does he provide any legally cognizable reason as to why he neglected to file anything until a few weeks ago. This is not and should not be enough. Hey, Nick. Arnold's forfeited his right, citation needed, to challenge the seizure by waiting for so long to challenge it and by offering essentially not an iota of necessary information to open default under Georgia law. As such, the state respectfully requests that this court deny his motion to open default. Request this court That's the last sentence? That's what you're going to close with? Am I reading this wrong? As such, the plaintiff, state of Georgia, respectfully request. So that's wrong. The plaintiff requests that this court deny Martinez Arnold's motion to open default and requests that this court, Martinez Arnold's, forfeit his interest in the seized property. Great work, Grant. wonder if they got the service right. I have on this date served it within on console record for Martinez Arnold. They got service right. That's good. They spelled their address right? They did. That's just a step in the right direction. Okay, Kat, let me see this. No. I'm just trying to get this thing to open. Hold on a second. I'm just going to go get it off of get the response off of the portal here. Actually, you know what? I should show you guys what I'm doing. So if you don't need to be a lawyer to do this, you can just go to just type in Fulton County Superior Court record search, and you'll come to this page. And you can actually register even if you're not a lawyer. You can just you can access everything here. So for this case, I'm just going to smart search and 2022. I just know the case number. Let's see here. Yes. And I can go to the documents. All the documents from the case will be here. All the documents will be on the side here. Sometimes they won't all get uploaded, especially with older cases. But you can see this. It's not up here yet. How did you get that, Kat? $421, $11.16. Wait, is this? Did Ashley somehow file first? That's funny. Okay. Let's see, let's read it here. Okay. I see Ashley already got to the point that I was making. That is funny. Yeah, so let's see here. Claim Martinez Arnold's response and objection to plaintiff state's motion for default judgment. Let's see, comes now Martinez Arnold by and through his counsel, showing the court. The motion should be denied for all of the same reasons Mr. Arnold has set forth in support of his motion to open default. The state's motion, pursuant to its order dated April 1, due no later than April 21st. The state's motion seeks default judgment against Mr. Arnold pursuant to the default statutes. The grounds that Mr. Arnold has not answered the complaint. On April 14th, 2025, in accordance with the provisions of 55B, Mr. Arnold filed his motion to open default, along with his affidavit, supporting documentation, including proof of payment of costs, and his proposed answer to the complaint. For all the same reasons Mr. Arnold advocates for opening the default, Mr. Arnold asserts that the state's motion for default judgment should also be denied. In paragraph 8 of the motion, the state makes representations of an unidentified attorney, but does not provide the court with complete information. As an initial matter, undersigned counsel did not represent Mr. Arnold in this forfeiture action until March of this year, when counsel inquired of the court regarding its order on the state's motion for default judgment. In response to paragraph 8, however, on August 31st, 2022, the Fulton County DA's office emailed Mr. Arnold's criminal defense attorney, undersigned counsel, that the state was actively serving a new warrant and re-indictment upon Mr. Arnold. That's actually useful for something else I'm working on. I'm going to make a note of that real quick. Okay. Mr. Arnold. In response, undersigned counsel asked for a copy of whatever was served upon Mr. Arnold. Undersigned counsel then said, also, I was informed that there might be a forfeiture or seizure action regarding some property that may belong to Mr. Arnold. Undersigned counsel then asked for a service copy of whatever forfeiture action might be pending and a case number. Undersigned counsel never received any response regarding the forfeiture. On December 20th, 2022, Fulton County DA emailed undersigned counsel a copy of the forfeiture complaint, and undersigned counsel responded by asking if the stay had been lifted. The court staff attorney responded the stay had not been lifted and was still in place. This is a nice touch. To that end, for the sake of brevity, Mr. Arnold incorporates, as if set forth fully herein, all the facts and arguments set forth in the motion to open default. That was a nice touch. And I think the state's motions in this actually are consistent with that, with what she said there. Let me see here. Is this one? Here, maybe. If I can't find this, I'll just move on to Demise McMullen stuff. But yeah, here it is. So this is the state's motion for default, and they're essentially confirming Ashley's version of the of events. It's this is the same discussion that Ashley referenced in the footnote. On August 31st, within 30 days after service, the attorney who represented Mr. Arnold contacted the DA's office and stated that she was aware there might be a forfeiture action or a seizure action. So that's, let me see, where did I put it? Oh wait, you wouldn't have been able to see that. Show you one more time. Yeah, those are some defaults here. And they have the same quotes, just quoted the same portions as Ashley was. So the state's already essentially corroborated her version of events in their own motion for default, which is kind of funny. Something you generally want to avoid. Hey everybody. Sorry, I had my chat up for a second. Let's see. Oh, Survivor Speaks is here. Yeah, Kat. That one threw me off. It being filed before indictment. Yeah. Hey Ashley, I didn't see what you said about. I wasn't watching chat, but if you clarify a little bit, I can answer. And yeah, let me switch gears now because that was exhausting. I want to show something that I've been working on. Let me switch this up real quick. 1 second. You can see my broken chat thing there. Okay, let's try this. So this is my little Demise McMullen project that I've been working on. So Demise McMullen is one of the defendants in the YSL case who was obviously one of the lesser known defendants. He wasn't included in the first trial. He hasn't really been included in anything so far. He hasn't really had a lawyer at any point. And I just wanted to run through the history. That's, let me see, it'll be 3 years in just, what, like 2 weeks? I think 2 weeks from today, actually. That since the original indictment. Or no, just over 3 weeks. Just over 3 weeks since the original indictment. And yeah, he's been waiting a very long time, and he hasn't really had any kind of due process at all. But the most interesting thing, I think, is that he hasn't even been getting notice of most of the critical events in his case. I don't know if you guys can see this okay, but I'm just going to start from the beginning and show all the instances in which he hasn't been represented or has, in one way or another, been just excluded from the process or otherwise kind of denied his rights. So for starters, I'm going to go to my okay. So this is the first, this is the service document that's filled out by the investigators in the Fulton County DA's office that they filed with the court to show that they served the indictment to the people who've been indicted. So this one was, you can see, it's September 6, 2022. And let's go to the second one. It was, you can see here, the indictment number is 1822273. That's the original indictment number. So by this date, this indictment would no longer be active. That one is, see this number here. Make sure there's nothing. Yeah, this is the May 9th indictment, and it's 1822273. Not the current indictment, which is this number here, 183572. But on August 31st, somebody, I can't read the name, I don't know what that says, she delivered apparently this indictment to Demise McMullen at Macon State Prison, which is where he was serving. Sorry, I'm a serious lawyer. His signature looks a little different, but anyway, yeah. So anyway, when they filed it, they put it under this indictment number. So I don't know whether he actually even got the operative re-indictment. It's kind of hard to tell from here. But that one's not really the biggest deal in the world. Go back to the next one here. So the next thing that happens is we have a couple of lawyers make appearances in the case. I don't know if I downloaded these. I'll just show them this way. Change this to enter of appearance. Here we go. So here we see, this is September 31st, 2022. This is the first attorney that comes into his case. And he's not a child, but that's beside the point. Then she's gone. Let me see, is this? Yeah, so this is the same lawyer. She moves to withdraw from the case 14 days later. Attorney Young had accepted a RICO case from the conflict defender. Upon being informed the client was also charged with murder, I notified the conflict defender's counsel that I no longer wanted to accept the case. Based on my assertions, without communicating to me, the conflict defender has sought new counsel for this matter. I don't know what she expected to happen there. I've been informed that I will not be compensated by the conflict defender, as new counsel will be compensated. New counsel will file entry and keep the court informed respecting where notices, etc., etc. So that lasted, I think, about two weeks. Exactly 2 years before Young Thug pled guilty. Then we have the next set of lawyers on, this is between the two. So between Attorney Young joining the case and leaving the case. These two lawyers, Bryant Green and Clarence Hollins, joined the case. And they last, this one? No. I don't know if I have it offhand. But in any case, they also withdraw from the case. Here we go. 4 days after they made their appearance on November 8th, 2022. As Attorney Hollins practices very limited criminal law, has only handled misdemeanors. Attorney Green only handles civil cases. So they also moved to withdraw, and they were both sets were permitted to withdraw on November 17th. As this will show, I can do the spreadsheet. So the attorneys are, the first three attorneys or two sets of attorneys were only there for a total of combined 17 days. And you'll see he doesn't get another attorney really until July of 2024. So it's just outside of 2 full years that he goes without an attorney. And let's see that he's basically cut out of we can basically cut out he's cut out of pretty much everything that happens in this case in the next couple of years. So I'll give you an example of that. This is June. No, this is one of my favorite documents in the entire case. This one, here we go. Order setting scheduling conference. This is June 27th, 2023. So it's like 7 months after his attorneys left the case. This court is going to conduct a scheduling conference with the parties in the instant case to discuss the scheduling of all outstanding motions. Before August 4th, counsel for each party shall file a list of all motions that they contend remain outstanding. Remember that McMullen doesn't have any counsel at this point. For each such motion, counsel will indicate whether the motion is contested, whether there's been a response. Then there's this Weather, Carl Weathers, the motion can be decided on briefs, and then they go back to the correct Weather. Whether the motion requires a hearing and an estimate of time required when a hearing may be necessary. And then it's 2021, which is off slightly. But let's jump to the next one. And scroll down here. This is the email where they sent out the document we were just looking at with the weather. June 27th, same date. And these are the attorneys that had been off of the case since November 17th of 2022. So these were emailed to well, not to McMullen and not to any counsel representing McMullen. Where'd my name go? So this is the next instance of this order. It has to do the same thing, the managing the motions. You say down here says, so the state nor defendant McMullen have responded to date. The state and defendant are ordered to comply on or before September 15th, 2023. If either party fails to comply, its pending motions, if any, will be deemed abandoned. And this time you can see they again email his former counsel. So he doesn't get any notice of this happening either. And one thing I forgot to mention is that when he had the attorneys for 2 weeks, some of them did file a few motions on his behalf. Nothing especially substantial, but he did have a few motions pending from those lawyers at this point. Go back here. So then shortly after that, September 15th, so about 20 days later, the state did respond with respect to McMullen's motions and his son's motions. And since this one was filed by, I think, Amanda Young, his first lawyer, this was filed by the second lawyer. And you can see they run through and the state does what it's supposed to do. Submitted the 15th day. And you can see they correctly mail this. That's his prison number. That is the prison where he was staying. So it seems like he probably got notice of the fact that the state was updating the court. Then just 10 days later, the court declares defendant McMullen's motions abandoned. So all of his motions that were abandoned, that were filed by the first two sets of attorneys, Young first, Amanda Young first, and then Green and Hollins the second time, were just determined to be abandoned by the state or by the court. So those are all null and void. So he didn't have any. He didn't receive any counsel. He didn't receive any benefit of counsel through this point, which is 16 months into the case. So that is the first bit of process that McMullen was denied. Let me go back to this one. So we're through here, through this part right here, and McMullen hasn't received any benefit of counsel. He hasn't had the opportunity to plead one way or the other, and that's bad because we're well over a year in at this point. And the next thing, let me see if I can find another example. Something that's interesting. So throughout all of this, the court was also mailing notices to Demise McMullen. So for example, this was a plea and arraignment notice, October 5th of 2022. And oftentimes you would, if you're in jail or prison, they'll have you participate by way of Zoom. But the thing is, they were sending, every time they mailed something to McMullen, they'd send it to his old home, his pre-arrest home. But he'd been in serving prison since 2017. So every time they mailed something, they would they'd send it to his home address that he hadn't lived at in nearly a decade. So actually, let me do a screen share. I guess you can't really see that, but anyway, I know I had a whole list of, I went through his file and found all the instances of mail getting returned undelivered, and he basically didn't get any notices for, let me see, it's almost 2 full years that they were sending mail to his old home address, and it was getting bounced back without any change to their means of trying to contact McMullen. And let me bring that PDF back up. That is a big piece of mail. There we go. Okay. So we have quite a few here. Plea arraignments. Got, what's this one? It's a motions hearing, October 13th. Same thing. A little bit later, this is November of 2023. You'll see that they were mailing stuff to the old lawyer, Clarence Hollins, who had been off the case for over a year at this point. Remember, he left the case on November 17th. Oh, just under a year, actually. November 17th, 2022. So, again, this would have been, let me see, a motions hearing or a motions calendar hearing, November 20th, 2023. Let's see. And then it even goes into March of 24. So a March 25th, 24 hearing, a status conference. This was still being sent to the old lawyer. See there, Clarence Hollins. Most recent one I have is, I think, this one. Yeah. This one's here. It's being sent May 22nd, so over 2 years after the initial indictment. It was still being sent to his prior residence that he had lived at since 2017. So over 7 years removed from that being correct address. And the curious thing is that whenever the state needed him to be somewhere, they would file something like this. It's called production order. You can see that, yeah. And with these, it basically tells Department of Corrections to bring you to the courthouse so that you can participate. And it's my half birthday. He's exactly 18 months older than me. And it's St. Patrick's Day. His name is McMullen, which I also like. Yeah, so he was in Macon, so they knew exactly where he was. They had the correct number. And yeah. When they wanted to get in touch with them, they could, but they frequently didn't by using the wrong mailing address. Okay, I just realized I showed they should really be redacting some of that information from public filings, but that's okay. Let's go to the next one. So the next point I want to make is that I don't think Demise McMullen was ever arraigned. I'm going to go back to the Odyssey website. go. Let's go to the RICO case. Who am I talking about? McMullen, right? Here he is. Okay. So here we see the first instance where they try to arraign him. It's September 8th. It's fairly late on in the process, but September 8th, 2022, Macon State Prison. That's his prisoner number we just looked at. It says need a C3 attorney, basically a public defender. They need a public defender appointed. And you'll see here again, October 5th, need an attorney appointed. Same thing, October 13th. It's not an arraignment, but need an attorney appointed. Plea arraignment, need an attorney appointed, and it just keeps going for some time. There was one last one, I don't think it might not be on here, but it was December, I think 29th of 22. Let's see if it's on here. Yeah, they don't have it on here, but there was a hearing. Oh, there it is, December 19th, 2022. Need to appoint an attorney, Macon State Prison. That's his prisoner ID number. So there's still no attorney appointed as of 12/19/22. And as far as I can tell, he was never arraigned, which is crazy because that should have happened immediately. The first arraignment hearing, I can pull up for you here. This one. This was this was August 18th, 2022. So this was just a week or so after a little more than a week after the reindictment was returned. And you can see all these people are getting arraigned, or they're waiving their arraignment. Miles Farley, Huey got arraigned, Williams, Gunna, Myrick. So all these people are getting arraigned, but McMullen wasn't there. And if you look at his calendar, what we're just at here. Here we are. You'll see that from the last date he was supposed to be arraigned, which was December 19th. It's about here. 22nd, additional discovery. That's a planned trial date. Nothing happens until June 27th of 2023. And at that point, I think they'd just forgotten about the arraignment. But, yeah, he basically just sat in I think it was jail or prison. I can't remember which one, from December of 22 through June of 23. And it looks like he was just never arraigned after that. So I think they just skipped that step entirely. Let me see here. I hope, let me see. Sorry, I lost track of the chat again. I keep doing that. IP Contract, is he still in custody? Yeah, he is. This is actually kind of an important point. He was convicted of something in 2017. And so he's going to be in, yeah, no, they're not allowed. They're not supposed to skip it. And it's possible to waive it, but I don't think he has to waive the indictment, making it ambiguous. And YP Klemchik, yes, he has been in prison since 2017. He should be eligible for parole somewhat soon, actually. 17. I know the latest possible date he could get out would be 2040. So is that 20? Yeah, it should be in the near future that he'll be parole eligible. I know you're being sarcastic. I should have been clear. I did pick up on the fact that was sarcasm, though. Where am I? Can't even tell what window I have up on the stream right now. Okay. Form of arraignment. There we go. This streaming thing's more difficult than I thought it was going to be. Okay, here we go. I think. I don't know if we need to look at this, but in case you know, this is the way the arraignment's supposed to go. Upon the arraignment of a person accused of committing a crime, the indictment shall be read to him, and he shall be required to answer whether he is guilty or not guilty of the offense charged, which answer or plea shall be made orally by the accused person or his counsel. If the person pleads guilty, the plea shall be recorded on the minutes of the court by the clerk, together with the arraignment, and the court shall pronounce the judgment of the law upon the person in the same manner as if he or she had been convicted of the offense by the verdict of a jury. In addition to any other inquiry by the court prior to acceptance of a plea of guilty, the court shall determine whether the defendant is freely entering the plea with an understanding that if he or she is not a citizen, then the plea may have an impact on his or her immigration status. This subsection shall apply with respect to acceptance of any plea of guilty to any state offense in any court in Georgia. Does one have to hire an attorney and file a lawsuit to get this addressed? Or is there a statute of limitations? He does have an attorney now, for the most part, kind of. Well, I'll get to that, but the court does have to take action, or the state does have to take action to bring the case to trial within a reasonable time. And let me see if I have any more things to talk about. Here on 325. Basically, there are just a lot of things that happened, hearings and orders that went by without McMullen having the chance to participate. I'll give you one example here. So this was May 29th, 2024, order setting requirements for a final plea calendar. And the final plea is the last, there ended up being another one, but the final plea is the last chance you have to enter negotiate a guilty plea. With the state can reduce the charges below what the charges of the indictment. So if you're charged with murder, they can negotiate down to manslaughter, and you can enter a plea to the lesser charge. And this is a big deal. It's somewhat similar to the arraignment, where you kind of hear the charges and you have an opportunity to plead guilty, but it's supposed to be much later on in the process. But you'll see that the parties were ordered to confer in advance. Let's see, defense counsel shall confer the defendant by June 21 to consider the state's offer in good faith. The party shall confer no later than June 27th. And he just didn't have a lawyer for any of this. So he was essentially cut out of this process entirely. And this is not his, that's not his number. It's 1166739. And this isn't the prison that he was staying at. So, this is the date. I believe this one was. Is it this one? I believe this is the same one, right? June 28th, yeah. So also when they sent notice of that by mail, they sent it to his residential address. his old address rather than the current one. So he wouldn't have gotten noticed that way. And he didn't have a lawyer. And yeah, he was basically cut out of that process entirely. He wasn't notified it was happening. Which doesn't seem fair to me, but anyhow. Okay, so here we go. We have the next attorney appointed on July 19th, 2024, which was shortly after the hearing we were just talking about, the final plea hearing. Let's go to this one. Yeah. I just want to play a little clip here. So there's, yeah, Lexi. How did Mender have 2 Ricos at the same time? I don't even know about that. I know that he had a separate. Ashley asked, "How does he have Mender have 2 Ricos at the same time?" I don't know. I know he had something with the was it the fight, the jail fight? I think. Let's ask a few minutes here. Can you hear that? No. Okay. Ooh. Is that better? Okay, so he had the opportunity to take a 20-year sentence for, I think it said voluntary manslaughter plus the RICO. Oh man, that's so bad. Okay, well, I'll get that better for next time. But the deal was that he, McMullen had the chance on December 19, 2024 to plead guilty, and he'd get 20 years, all of which would be parole eligible. And he turned up, he rejected the deal. Let me see here. Okay. So this is going to be his current attorney talking. This is December 19th, 2024. And hopefully it works this time. Remember, he was appointed July of 2024. So let's see if this works.
You know, Mr. Dark, I know that some of you started the trial that already occurred, started voir dire, and some of you didn't, and I don't know what Mr. McMullen did. Was he a part of the past trial when it started?
Your Honor, Mr. McMullen tells me that he's in custody for the past 2 years with no counsel, so I don't believe that he would participate.
Okay, all right. And when did you become involved in the case, Mr. Dark?
I just was appointed, I cannot remember right offhand, but I know it was within the last 60 days, I think, Your Honor, 60 days or more.
Your entry was August.
August, yeah.
Now, that's a lot more than 60 days. That's more like 5 months.
It's August in the other case, and then in this case it was in July 19th.
Okay.
Yeah, 'cause
5
he has
months.
some other case or something.
Yes.
But Your Honor, as I was saying at the last court appearance, I just got the discovery on this case on, I think, the 11th, and then I don't know what his other matter is at.
And as I said to you at the last conference, you should have been able to get all of the discovery from you said there was no prior attorney? Okay, well, it was your responsibility when you were appointed to the case in July to reach out to the state and say, hi, I'm in the case now, I need the discovery.
Okay, so 3 minutes ago, his client had just turned down the guilty plea that would have, it probably would not have impacted his total time in prison by that many years. He's in until his entire sentence would have been parole eligible, and his current max time is through 2040. So, I mean, at most we're talking a couple of years here or there. And again, I don't want to make light of the fact of time in prison, but the deal would not have impacted his total time in prison by an enormous amount, most likely. And he made that decision, McMullen made the decision whether to plead or not to plead with an attorney who hadn't even reviewed the discovery yet in the case, despite having been appointed 5 months, exactly 5 months to the day prior in the case. Is Mr. Dark still his lawyer? Yeah, he is. And you'll see the next hearing. I don't have video for it, but I have a transcript. Go here. And, you know, I don't want to drag this guy through the mud or anything, but, you know, for the client, it should be, the discovery should be reviewed before people are pleading or not. So this is from February 7th of this year. Okay. So they're discussing here. Yeah, Kat, for sure. And she brought it up. I think you were streaming it was the hearing after the acquittals or the verdicts in the first trial. There's that status conference, and she mentioned something about discovery then. So here, saying Mr. Dark wanted to withdraw, and let me see. This is Whitaker speaking. The only thing you told me at the bench the last time you were in court, you had a court date in April that you needed to be at, and that's the only thing you said. And you otherwise represented once you've got assistance that you'd be ready for this trial. So ultimately, I'm going to grant your motion to withdraw, but she's not happy with him. Stark says, I apologize. You want me to respond? Dark says, I apologize if the court takes that position. It's not my intention. Whitaker says, I'm not saying it's not. What I'm taking issue with is that you seem to suggest you've already alerted the court to the struggles, and that is not true at all. Of course, has had a personal issue, and the court's Judge Whitaker's upset with him, and reasonably so. Mr. Dark says, well, you are blasting my personal business, and that's difficulty. It's difficulty in communicating that the last time it's not something that I want to blast. I don't want my family on media and all of this stuff, but I don't have much of a choice. And Whitaker says, again, I agree with her completely. What I'm trying to do is make sure that people who are on trial for murder have the representation that they need. And if this was actually going to be an issue, which it clearly is, this should have been brought to the court's attention well before. I was told at the beginning of December that this case was going to trial in late February or early March. So this morning, at what is supposed to be the second pretrial conference, should not be the first time that you say to the court, you know what, I'm not in a state to be able to do this. So I'm going to grant your motion to withdraw. And with regard to what that means for the state, I think it's going to be, what's going to happen is that Mr. McMullen's case is going to be severed because she doesn't want to wait for the other two, doesn't want to wait for McMullen to hear the Garlington and Eppinger cases, the other two defendants that are waiting trial. Let me see. Then Eddie Abate says, we'd object to that, to be quite frank. This will be, so we're going to have 3 trials. I think it would be more beneficial in the administration of justice and judicial economy to push the trial up another month or 2. It says, well, let me find out from the public defenders what they can do in terms of representation, because Mr. McMullen, this is going to be his 5th set of attorneys, which nobody should have to deal with. That's not his fault. If they can get somebody in there quickly and we can get them up to speed, that's one thing, but I mean, he sat represented for over a year. And again, it was much more than that. He went through 3 different sets of attorneys in rapid succession because of, I think, issues with Georgia Public Defender. Had this attorney since July, but this attorney is not able to continue. And again, actually, he charged 7 people with that murder. I have at least 5. I don't know who the other 2 are. Charged Kendrick, Stillwell, McMullen, Cobb, and who's the 5th one? I can't remember what the 5th one is. So this one last point is something we're going to come back to, but they're discussing whether to delay the trial. And about this says, I think it'd be relevant for the court to be made aware or be reminded that Mr. McMullen, he's serving a number of years in corrections still. So waiting for counsel when he kind of trails off. But the point seems to be that because he's already in prison, there's not as much prejudice on the wait. There's one last thing in this here we're going to look at. Okay, here we go. Court. Mr. Dark, I know one of the issues that you said you faced when you first were appointed to represent McMullen was that you didn't have any discovery. Now, you apparently didn't take any steps to get the discovery from the state, but you have the discovery now, correct? Yes, Your Honor. I have the link, and I also have a 8 terabyte. Okay, let me ask you this. Can you just get the entirety of your file and bring it to the court, and I will hold it. I'll not look at it. I'll hold it so that whomever is ultimately appointed, I can give that to them. Have the benefit of what we've done thus far. Stark said, yes, I can read the discovery and I can try to have it here. I mean, everything you've worked on. I mean, your entire file. Okay. Says, I appreciate that. Is that something you can do? When can you get that to us? Mr. Stark says, I'll have to look through the file to see like consular impressions and notes and things like that. It's like it doesn't want attorney-client privilege material to the court. Okay, I mean, you're welcome to put it in something sealed, but I mean, your attorney impressions and work product, what have you, might be beneficial to Mr. McMullen's next attorney. Of course, I'd hate for he or she to have to start from square one if you've already gotten to square 25. The problem with that is that we have this, the discovery receipt. We can see it was filed on the day before what we were just reading. I guess it was dated 2 days before. It's I, Letitia McCollum, counsel, employee of counsel for Demise McMullen, has received an 8 terabyte drive from the DA's office in case 22 SC 183572. I retrieved it from the DA's office from Christian Adkins, DA Adkins, on February 5th. So it seems like he had just gotten the discovery within 48 hours before that. So I don't think he'd gotten to square 25. And that probably should have been disclosed, but I don't think he'd done any discovery work at this point. And we're pretty far along at this point. Yeah, he sure was. And throughout this, they're going through prospective jury selection questions. They're arguing motions, and they're well along in the pretrial process. And as far as I can tell, there hasn't been any discovery review, any doc review. And that pretty much brings us up to today. Let me just switch to, let's check the state of the docket right now. See if I'm forgetting anything. Let's see. Better, but yeah, so this is what we were just looking at. This is the discovery receipt I just showed. Rule 22, that's a media related request. That's one of the prosecution's motions. This is the hearing we were just looking at the transcript, reading the transcript from. These are appearance, they're scheduling conflicts, they're not important. There's a pretrial conference where they're discussing motions. And yeah, the next thing is the May 6th pretrial conference, which is about 2 weeks from now. So McMullen has gotten all this way without being arraigned, without really having effective assistance of counsel, as far as I can tell. And he's, I believe, the last of the 5 people being charged with count 1 of the indictment, which is the murder. After we get through, or count 2 of the indictment, which is the murder of Donovan Thomas. Let me see, Ashley. Yeah, that's right. Remington, Woody, Shannon, Yak, Nard, Garlington, Cobb too, I think. Bradford. He's the one I always forget. Yeah, no, Shannon, I think Shannon, somebody else. I think you're right. But yeah, I think that he's an easy target for the DA's office to get a conviction on this count. He has been involved in a shooting before. He's been conceded guilty to it. That's why he's in prison right now. He hasn't really had any effective assistance of counsel. He doesn't have the money to hire the best lawyers. Max isn't going to be there defending Shannon. Doug's not going to be there defending Diamante. So he's not going to get this sort of secondhand benefit from that defense. I think I think that they're not letting him, they're not pausing his case because they want to get at least one conviction on the Donovan Thomas case. And I think that he's their best chance. And you have to remember that Shannon was specifically identified by them as the shooter, and he was acquitted. So by all means, as I see it, he should be Shannon's out. Yeah, he is. So yeah, as far as I see it, he absolutely should be. Should be null prost. If the shooter has been acquitted, then that necessarily follows. Well, not necessarily, but it should follow that everybody else should be acquitted as well. But one thing, I want to look at one case real quick, at least, which is fairly recent. and it has to do with the right to a speedy trial. And in Georgia, there are two types of speedy trial demands. There's the state statutory speedy trial, and then there's the constitutional speedy trial. And you may remember Young Thug filed a state speedy trial, a statutory speedy trial request, and that's why their trial happened so fast. But there's there is a constitutional speedy trial that it's not specific, but it is still used in Georgia. It's not, you don't see many wins on it, but it does happen. I just want to go over the test for that here. Let me open this other one too. This is what I was looking for. Sorry, I forgot there's one more thing I wanted to show. Okay. Okay, I'm just going to read through the way the law applies here within the context of a constitutional speedy trial claim. So a constitutional speedy trial claim is evaluated under the two-part framework set in Barker versus Wingo. As we explained in Reading 2, this is actually the third time that this case had come before the Supreme Court, which is kind of crazy. But it says, first, the trial court must consider whether the length of time between the defendant's arrest and trial is sufficiently long to be considered presumptively prejudicial. If not, the speedy trial claim fails at the threshold. A delay of 1 year or more is typically presumed to be prejudicial. So we'll be at over 3 years. When that threshold is crossed, the trial court proceeds to the second part of the framework, applying a context-focused four-factor balancing test to determine whether the defendant was denied the right to a speedy trial. These four factors are length of delay, the reason for it, the defendant's assertion of his right, and prejudice to the defendant. So those are actually fairly straightforward, but let's see the application here. So A, length of delay. The length of the pretrial delay in absolute terms plays a role in the threshold determination. However, it also wears another hat as one of the four interrelated criteria that must be weighed in the balance at the second stage. So first, you have to have a long delay, but then just to even get to the analysis, yeah, he is. K-Tally, that's right. Is he? I'm second guessing myself. Charged. On count two. Let me see. Nope, no ground on count two. I think he was one of the initially named by Rudy as a prospective as being involved in it. Okay. So, let me see. So, while similar, the presumptive prejudice threshold and the length of delay factor are separate inquiries. In considering the length of delay, a court must consider whether delay before trial was uncommonly long. Delay that can be tolerated in a particular case depends to some extent on the complexity and seriousness of the charges, and a delay may be uncommonly long when the case is not prosecuted with the promptness customary in such cases. Uncommonly long delays should generally weigh against the state at least lightly. It's not in this case, but there's another case that says failure to appoint counsel is not a good reason. It's not a justifiable excuse for delay. But anyway, next is reason for delay. The trial court also erred by weighing the reasons for delay factor neutrally. In considering the reason for delay, we've explained that the trial court must consider which party was responsible for the delay, whether the delay was intentional, and if it was intentional, what the motive was for seeking or causing the delay. a deliberate attempt to delay the trial in order to hamper the defense should be weighted heavily against the government. An unintentional delay, such as that caused by the prosecuting attorney's mere negligence or the trial court's overcrowded docket, should be weighted less heavily. Let's see. In this case, they found that the reason for delay was the fault of the state. It says the assertion of the right to a speedy trial. The trial court weighed the assertion of right factor neutrally and did not abuse its discretion in doing so. We've explained that this factor asked whether the defendant asserted the right to a speedy trial in due course. The factor focused on the timing, form, and vigor of the accused's demands to be tried immediately. Although an accused need not demand a trial at the first available opportunity, his failure to assert his right with promptness will ordinarily weigh heavily against him. Let me see. Let me see if I can find a good point. I think it might be a different case, but yeah, there's another case that says that if you don't assert your right because you were never appointed counsel, that's not the same as failing to assert your right to a speedy trial. That's just not being able to. Then the prejudice, the trial court did not use discretion by weighing the favor heavily against Redding. The prejudice associated with an unreasonable delay includes oppressive pretrial incarceration, anxiety, and possibility that defense will be impaired, and loss of exculpatory evidence. Of these forms, the most serious is the last, was the inability of a defendant to adequately prepare his case. Excuse the fairness of the system. Let me see. So that is one thing. But there's one interesting, I said I would come back to this earlier. Let me see here. I want to show this. Let's say that this is and you plead guilty in 20, this is your current sentence. Can you see this? Yes. And let's say you get sentenced to, you're going to have a 10-year sentence, then you plead guilty immediately. Yeah, that'll have to do. Here's 1, 2, 3, 4, 5, 6, 7. There we go. Now, let's say you don't even have the opportunity to plead guilty for 10 years until after 4 years have passed. Or say, let's say 2028. So 1, 2, 3, 4, 5, 6, 7. I don't even know if that's the right number. But this is all, let's say this is just delay. So this is extra time that you have to serve in prison that you wouldn't have had to otherwise. Because you don't get credit for time served if you're already in prison. So at this time, you would have already been in prison on your current sentence. So you have to start your sentence right here. So even if you're serving these two sentences concurrently, you're only this is your first year of service. This is year 1, year 2, year 3, year 4, year 5. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. So if you plead guilty immediately and you have a 10-year sentence in 2025, you're out by 2034. But if you get a delay of 3 years, this might be Tom Jake. So does he have a new attorney now? Hopefully they'll address all the mailed motions. No, he's in prison. No, he still has the same attorney as he did in February. No, I think he's in prison, or I think he's actually in Vice Street now, but he was in prison before. Did Winfrey get 7 years for a gun charge he already served? I think so. I can't remember what it was the RICO count though, so I don't think it was the gun itself, but yeah, I mean, that's the same in this case for McMullen. He's getting, one of his overt acts is the thing he's currently in prison for. I think that he accepted responsibility for in 2016. But this is all prejudice right here. So if you can't plead for 3 years, then you're losing 3 years of concurrent sentencing time. So your prejudice of the delay is basically a day-for-day loss of time served. If you don't have any delay, you're out in 2034. But if you do have delay, you have to wait the extra 3 years on the back end. So it's people who are already in prison and serving a sentence are, I think, so the highest risk for a prejudice, suffering prejudice, if there's an undue delay in their case. And it's just substantial prejudice. And especially in McMullen's case, where he pleaded guilty in 2017 to essentially the same set of circumstances. Accepted responsibility, acknowledged what he did, and made the deal with the intent of getting out with enough time to live a meaningful life. And now I think he's being targeted for stuff that he's already accepted responsibility for and is serving sentence for. And states essentially, first of all, going back on the deal, but they'll also be using his first admission, his first acceptance of responsibility, to punish him a second time, which is, I don't like. Might become Jake. When they took the machine gun from the thug's house, how many people can they charge with one gun? I mean, they can charge everybody with constructive possession of the gun. Eventually, it's difficult to. You have to show that somebody actually meant to exercise control over the gun. And I don't even know if it was any of those guys that they charged that really had any connection to the gun. I'm sorry, Nancy. I'm trying to do better about that. I meant to have the chat show on the screen this time, but I think I messed it up. Let me see, is there anything else I have on McMullen? Show. Here we go. I'll show this one last thing here. So this is the plea transcript from his just give me the date. February 15th, 2017. This is Demise McMullen's guilty plea. This is for the shooting of Dexter Montgomery. Some of you might remember that name from the YSL trial. And get down to here. This is the factual basis, just to show that Fulton County was fully aware that this was a YSL thing. It says allegedly. So this is Charlie Bailey. He's involved in a lot of the YSL prosecutions from this era. Your Honor, this case proceeds to trial. The state would expect to show that around April 12, 2015, members of YSL, which is a subset of the Bloods gang, and members of the IF gang, Inglewood Family and ABG Atlanta Blood Gang, which is another subset, were in what can only be described as an ongoing gang war. We would expect the evidence to show that on April 12th, individuals approached a gas station at Brownsville Road. It's a pretty dark story, but it's not as if these are new facts unknown to the state, and they're only getting to prosecute him now. They've known about this since, again, 2017. And it wasn't that they didn't know or allege that there was a YSL involvement. They did. So this really just feels like revisiting a past plea, and it's honestly, even with Rico, it's so close to double jeopardy, I think. How was that your affair? Isn't that double jeopardy? Yeah, Kate Talley. Usually Rico is separate from the underlying offenses, but I think in this case, this specific case, is close because I think there was let me show you. There were gang counts in this one. And so there's essentially a conspiracy element to it, and it's many of the same underlying facts. Consider double jeopardy. It's close. Just search for. Let me see. But yeah, so there's just a lot of overlap between this case and the current case. I think that they knew on this date that he was connected to YSL. This was after the Donovan Thomas killing. The RICO charge, there's no double jeopardy. That's mostly true. I'm not completely convinced that's true in this case because of the gang charges. But I mean, I'm sure that's what the state will say. Anyway, yeah. So that's mostly my point. Not as thought through everything as much as I would if this were an actual brief, but hopefully that gives you an idea of where his case stands. He still hasn't been arraigned, still hasn't had any effective assistance of counsel, still hasn't had a chance to plead guilty, still hasn't really had any motions filed on his behalf. There's one that I don't think highly of. I think it was subpar. And I think he's, hey, look at that. I didn't notice that before. And yeah, I just think it's just on a path for an unjust verdict, an unfair verdict. And yeah, I'm concerned about that. Let me see. I believe Thug pled guilty to the machine gun. Yeah, he does. There he did. Does that take that gun out of the picture for other defendants? I mean, in theory, more than one person can possess it, but I don't think the others would need to worry about it. Let me see. Man, I want to show you guys, see if I can find something fun to show before I wrap up for the night. Ooh. Let's see. I don't know. Any requests? Any questions? Any topics to go over? You can tell Dexter Montgomery with the G case. Oh, that's crazy, Ashley. I didn't know that. Let's see. Looking through my list of motions, see if there's anything interesting to go over. Here we go here. No. Did I hear about Shannon Sharp? I did. So I saw the headline. That's about it, though. I don't know if I'm going to be reading too much about that. They didn't make it a plea. Yeah, Kat, that was ridiculous. Let's see. Let's see, any fun lyric stuff? I have an idea. I'm going to show... Okay. How much of this can you see? That doesn't work at all. I wanted to show you guys. The different files that I have in the YSL case. See if there's anything that anybody wanted to see. But I don't think you guys are going to be able to see that. Let me see. Yeah, anyway, I think I'm going to be making all this public soon. I had it on my Patreon for pay right now. But I think I'm just going to make it public. I don't think I do enough with all these files. Yeah, I think I'm going to be just releasing all this on my Patreon for free. So everyone can see, look through all the stuff they want to. I'd rather just share it out with everybody. Yeah, I definitely want to cover the Lil Durk thing soon. Lil Durk case. This motion to dismiss was delightful. I don't think I have the voice to read the whole thing right now. But there's one little bit in here. What was it? Omniscience? No, prescience. This right here is just A+ work. We'll do this paragraph. Attached is Exhibit 1 of this motion is the declaration of Justin Gibson, the producer and sound engineer who recorded Wonderful Wayne and Jackie Boy. the song where the cited lyrics originally appeared. Gibson recorded Banks's verse, which Banks wrote and recorded simultaneously during his recording session on January 25th, 2022. Gibson uploaded the track at 5:39 p.m. that evening, saved it at 6:33 p.m., and finalized it at 7:21 p.m. Mr. Banks's January 2022 lyrics, therefore, could not have been about S.R.'s homicide in August 2022. Unless the government is prosecuting Banks on a theory of extrasensory prescience, the lyrics could not have soundly informed the grand jury's findings of probable cause. It's perfect. A+ work from Drew Fondling on that one. I think I'll probably read this whole thing at some point for stream, but this is a lot. I think I just saw the words TMZ. That's concerning. But yeah, I'm really looking forward to covering this case. Anything with lyrics is definitely a plus. Hey, Nancy. Where are... Let's see if I can show any more of these. Let's see. I'm going to show you something from a little project that I've been working on the side. Does this work? So this phrase is supposed to be exactly about a specific. This is taken from a social media post. This quote, and it's supposed to be about a specific event, a specific killing. And it's a verbatim quote of a song that came out within a couple of weeks of that exact date. And this is a YFN related case, or if gang related case. Let me see. This is the same case. Co-defendant Cortez White. No need to keep it secret here. But same thing. Literally verbatim quote of a song by Future in Atlanta that had came out 6 days before. This was quoted as being a gang-related post, specifically referencing the crimes, when in fact it was a direct quote of a song that was big in Atlanta, literally that week. And anyway, that's part of a bigger project I'm working on, and I think I told Kat a little bit about it, but it is pretty closely tied to the YSL case. Some of the people's names show up in the Operation Planters PowerPoint, if you remember that. But yeah, lyrics are generally not reliable evidence unless they're very specific. But oh man, I hope I didn't show anything there. But yeah, I think I'm gonna call it a night. I'm gonna take the dog outside. So chat, let me know where I'm originally from. I'm from Maine originally. Yeah, K-Tally, that's right. The fact that a person who's a fan remixed a song and put it out, and allegedly Dirk got charged for him. Hey to dog? Oh, I just mentioned my dog. Okay, I'm gonna go get my dog so you can see the dog. This is my baby. His name's Carmi, or Felony Murder for short. Just just go to my neighbor's house and borrow the dog. And just show him on the stream for hours at a time. Yeah, I'm from California. I grew up in Maine originally, though. I've only been here for a few years. Sub. I mean, he got me first. I went to the shelter to get a kitten, but then I saw this one. He looked all scared, and I thought I need to get him. He's my baby. He's very needy. He likes to watch me when I work. Sometimes I let him sit in my lap when I'm typing stuff up. But yeah. Okay. I'm going to take this one outside. And there should be some news soon on me actually doing lawyer work that I hope to share with everybody. Hopefully this week. I'm excited about that. May have another case in Georgia related to the YSL case. We'll see about that. If that comes to fruition, I'll talk about that soon. But yeah, I'd be excited to work on that one. And yeah, I hope you enjoyed it. If you have any requests for topics or questions, definitely. He's a cat dog. He can be kind of cat-like. If you have any questions or if you want me to cover anything, just let me know, and I'll definitely cover. Yeah, I'll definitely cover anything you guys want to cover. Youngies. I hope so too, Epi. I believe they're Tuesdays, cat. I'm sorry. Oh man, I should make Lizard Walk like my outro song or intro song. All right, guys, I'm gonna call it a night. Have a good night, everybody.